Hello, my name is Rune Fardal and I'm from Bergen, Norway. You can see my hometown. Some of you maybe have visited Bergen, so you should recognize these houses near the harbor. But what I want to talk to you about today is human rights, especially regarding childcare services, the so-called Barnevernet in Norway. And I have made a homepage on the internet that you can access with a lot of premises from the convictions in human rights court. And they are very useful because they are the highest law in all the 46 countries in European Court of Human Rights. And that should be about probably over 700 million people that this is the law for. You will find this page in this address here, sakkyndig.com/echr.html. And when you enter that one, you will get this page. This is a picture of the Human Rights Court in Strasbourg. And the page I have here, what you come into, is in Norwegian. But, yeah, I can take the language afterwards. This is a list of all the cases that has to do with the Norwegian childcare service, which they have lost in the European Court of Human Rights. You have the famous Strandlobben and others. You go into that page and then you get the whole conviction, all of it, PDF format. And that goes for all the other cases, FC, which is Norway, KI and AK, which is Norway, and so forth. The last one that came 12 September 23 come in 3 cases, which 2 of them consist of more than one. One consists of 2, one consists of 6, and then there was 1 single. So together 9 cases against Norway, Norwegian childcare system. And then I have put in some others important cases, because as I told you, the decisions in European Court of Human Rights is not just for Norway. It's about 46 countries, over 700 million people are attached to this. So if it's Belgium, Italy, Sweden, whatever, that's the highest law. Here there are some high court decision from Norway and some other decision. This is 3 special decisions that came in 2020 because the Norwegian High Court had to correct the Norwegian law after all these convictions. We have now over 25 convictions against Norwegian childcare services. And then there are some from Children and Family Department. That's as a sum up of all the decision, what they have to change in the Norwegian law system. And there are some cases that did not come into Human Rights Court because they was ill-founded or inadmissible. They all stay here. The last one was Hernhult vs. Norway, which come 28th September. But all of you out there, you probably understand English since you listen to me. But to get this page so you can use it, I use Chrome now, and here I have translation. Google Translate. Translate this page. And then I can choose what language. I choose English. Now, most of this page is translated to English, as you can see. ECHR cases, Supreme Court Grand Chamber in Norway, Ministry of Children and Families, you see, all the text now is in English. And if you are German or French or Italy or Belgium or Spain, whatever, choose your language. We are over 700 million people, and these decisions inflict on all of you. And the case itself, for example, Peterson and others versus Norway, that decision is in PDF format, but it's in English. And some of these decisions are also in French and other languages, Portuguese, Spanish, German, different languages. But here, what I put up here is the English translation. So you can easily go and see all of them too. So this is a very important tool to use when you have, this is specifically against childcare services in Norway, which is famous in a negative way all over Europe. But it also is the law for your childcare service in your country. In all the 46 countries that's under European Court of Human Rights, this is the law. So, okay, this was the first page, and this is not the most interesting one. This is just the court decisions, and down here I have some account if people like to support our work. VIPS system, that's a money transfer system. You can scan and just send money if you have a Norwegian account. Not so important. But what is important on this page is the picture. Click, let's get this back to English. Google Translate this page, English. Now, click on the image for a list of all premises. Click on the picture here. You will be directed to another page. And this too is in Norwegian, so I'm going in, translating the page, translate, English. Now, 517 premises from the European Court of Human Rights checklist. In the beginning is an explanation how you use this page. I will just try to show you very simple now. And then there are some keywords, not so important. The most important is how you use it. This is the list. Here are the different cases. They translate little strange here. Lobes, it's a Loben case. Don't care about that. They say Loben concurring opinion, KO and VM against Norway, and some other things are coming up. But the point is, this is a list of premises taken out of all these court decisions. And this is the law in 46 countries for over 700 million people. This is important. The list is, in the middle here is a text. You see a text list. It's a short description of the premise. If you move your cursor out to the number here, you will see that the court decision from that specific court, Loben premise 208, is coming up. So you can read it in English, and you can read what I have marked in yellow. You move away, it disappears. You go into another one, premise 212 is coming up. That's how it works all the way down, and there are over 500 of them. On this premise here, you can click into, for example, premise 222, Loben premise 222. This is a picture, so it doesn't translate, but you don't have to translate, because here is the English text, the one you got up when you move over the number. Norwegian translation, and a short Norwegian text, which is the same as under the text column. This one. So you have the premise itself. You have the short, it was 222 it was in. Observation must be up to date and comprehensive. 2 years is too old. So if a psychology report is more than 2 years, European Court of Human Rights say that's too old. You have to make a new one. And that's important premise, because childcare service in Norway and probably in your country, they finding stuff that is 10 and 20-year old and use it against families. This premise say must be updated. It's the today situation that is what's going to make the decision. Well, that was this column and this one. Then you have this column here, which say green. When you have a problem, let's say adoption, you go through here and find, oh, this is about adoption. Okay, I mark this with green. And then I go down here. Okay, I have, oh, this one I need. Oh yeah, and this one I need. And after a while, you have a list of that you have marked out here. Let's take the two other colors just so you can see. Gray is just changing this this field to gray, and white take away the mark. So I put the green back, then I go back down. Okay, you see it's 500 and I think 17 premises. So when you come to the bottom, here is Jansen versus Norway. Here is Tuomela against Finland, which was a case about Article 10 of the Human Rights Court. And we have Olsen, the Swedish one from 1988. Anyway, when you come to the bottom, you can click on the green here, and then a list of all the decisions that you marked is coming up. So you have a separate list of that. Here you can go in and see, maybe you have 20 and you don't need everybody. Okay, maybe I don't need this one. Okay, delete it. Okay, we have 3 left. These premises you use in your case. You can use them in court writing to court. You can use them in meeting with childcare. Use them up against your lawyers. Tell them, use this to help us win this case. This is in short what this list does. And then there are some, you can list in pop-up windows, you can put a list in a new window, you can delete the list or export it to Excel. So you see, this list is very important because this is the law that is over your national law. So if this is broken by the childcare service in your country, they break the human rights. They are human right violators. And this list, you don't find it anywhere else, because it has taken me a long time both to pick out all the premises, every decision I have found about Norwegian childcare service, and find what the courts say that is deciding for the human rights. Everything is found. I have programmed the page, and trust me, there is a few line of programs here, some 10,000-20,000 lines, but this is working. And by translating by translating this, you can use it in your language. If it's English, Belgium, Netherlands, Germany, all the 46 countries probably stay on the list for translate. You see there are Russian, Romanian, Slovak, Hungarian, German. Here you find it all. So you can translate and you get the court decision is in English. This text will be translated to your page. This is the link which I showed you, and then you can pick out and use the color marking here. This one is a fast link. Go to bottom of the page, and then you have one other here. Go to the top of the page. So this was just a short introduction. By today it's 517 premises from the European Court of Human Rights. This is a checklist that you can use when you have a case against the childcare system. And remember, as I said already, this is the top law in all of my member states, 46 states, that is under the Court of Human Rights. That's over 700 million people. That's quite a bit. And this is the top law. So now, if there are conflicts between your national law and this one, this is the one that rules. Even your high court doesn't go over this one. So if it's a city court, if it's a Supreme Court, a high court, whatever, this one trumps everything. So these premises are important. And trust me, I go in meeting with childcare every week, different places in Norway and around. And when I bring these arguments, for example, the one we just talked about, observation must be up to date and comprehensive. 2 years is too old. If they come up with a psychology report that is 4 years old, I say, that is not legal anymore. You have to take that out because according to Loben premise 222, it must be updated, and 2 years is too old. So it must be less than 2 years. And you have the law on your side. So trust me. And one thing last, you can search. I click find. I write foster. I find 20 hits with foster. Let's take a look. Here. It is not possible to create a good atmosphere with few or short meetings where foster parents are present. What? Okay, so if the foster parents are present when you go to see your child once a week, once a month, 2 times a year or whatever, when they are there, it's not possible to make a good atmosphere. They must go out. Use the law. Let's kick on to the next one I find. Foster parents' views must not be given more weight than the family's interests in family life with their children. And this one, the EMD, that's the short for Human Rights Court, criticize that important assessment of child are unilaterally based on foster parents who have financial interests in the child. You see the power in this list? Here. It is the responsibility of the authorities to introduce, let me take away the green one here, it's popping up a lot of thing here, take away that one, white. It is the responsibility of the authorities to introduce measures that counteract the risk of families not being reunited. When this has not been done, Attachment to foster parents is not decisive. So if the childcare has not worked hard to make your child connect to you, well, the child's connection to the foster parents is not decisive. When you know these things, you can go on and on and on. There are 500 here. Children's reaction during socialization can have various causes. You know, when you go to meet your child in maybe 2 times every month, they can have a reaction before or after. Causation in relying on foster parents' information. Be careful when you rely on foster parents' information regarding that. Maybe they say, oh, after this meeting with the parents, the children was so angry and they do this and that. This premise say, be careful about relying on the foster parents' description because they have economic interest. They want to keep the child in many cases. And they don't want to say, oh, the child was very happy. They want to cut down on the meetings between parents and children. So you see, this is an important list. There are one more thing I see here. If it say BFD, that is the understanding the Norwegian Child Department have of the decision from European Court of Human Rights. When you click on this picture, you will get a Norwegian text, and this is a picture, so it doesn't translate. But the letter here may be possible to translate, but it's page 4, third section. I call it premise 7, and here is in Norwegian. But when I come to think of it, on the first page, this document stay in PDF format, and that should be possible to translate for you. So when it say these BFDs, that's the only one that is not translated directly, except for the short what this is about that come up in this list. And remember, all these things, and then you have a high court decision. HR is Norwegian High Court. We say Høyesterett, highest court. That's also in Norwegian, but the text here, you find the decision in the list in the last picture, so you can translate the PDF. But anyway, everything else is KA and AK. These are judgment from human rights courts. So try to look at this list, translate it into your language, and use the premises. If the childcare is knocking on your door, taking your children, want to take them, or whatever. This is the highest law. And if I go back one page, let's see if I come back to that one. Here you have the court decisions from European Court of Human Rights. Here is Vanelli versus France, which was about the right to be present when the psychologist is questioning other people in your case. You didn't know that, did you? That one say you can. But it's on the list. So you get all the court decision that is related to childcare, and some special for Norway. Here are the decision I told you, HR. This is PDF, so I think it should be possible to translate this one too. But this is just derived off from the other court decisions in European Court of Human Rights. So it's actually under that court decision from Strasbourg. Well, that was a short introduction. I think I'm going to have some film coming up where I explain how you use this for a special problem. For example, foster parents or meetings with children, or one of the biggest problem with Norwegian, why they lost so much in Norwegian, was that when they claim something, there was no basis for the claims. Oh, this child is this and that, or these parents are this and that. And then the court in the human rights asks, oh, what do you base this on? No, we don't know quite about that. That is an important thing. I'm coming back to that, but for now, you get into this page, you click on the picture, and here you have all the premises for this, and you can translate with Google, translate the page, and here to English, and there you have it. Okay, ain't gonna make this too long, but try it, see if you can use it, because I see when I use this, childcare services are getting problems, serious problem, because they are not used to talk on the top level. They used to talk down there in their other levels, what they feel and what they think and everything, with no basis. Okay, that was all for me for now. You find this in this address, sakkyndu.com/echr.html. ECHR is European Court of Human Rights. Okay, have a nice day and study this and spread it all the way around Europe, because these premises are the law in 46 countries and for over 700 million people. Have a nice day.